It is the purpose of your intended visit to the U.S. that determines what visa options are available to you. A visa, however, does not automatically permit you to enter the U.S. It simply indicates that your application has been reviewed by a U.S. consular officer at an American embassy or consulate, and the consular officer has determined that you are eligible for the visa classification for the specific purpose you sought. Consular affairs are the responsibility of the U.S. State Department. While a visa allows you to travel to the United States, it only gets you as far as the port of entry, airport, or land border crossing, and allows you to ask an immigration officer to allow you to enter the country. Only the immigration officer has the authority to permit you to enter the U.S. He or she decides in what status to admit you and how long you can stay for any particular visit. Immigration matters are the responsibility of the U.S. Department of Homeland Security. As we noted above, it is the purpose of your travel to the United States that determines the appropriate visa category for you. There are two main categories of visas, immigrant and non-immigrant, that you can apply for, and it is the nature of your intended visit that determines what visa category you may fall into. Purpose of the visit. How does it determine the best visa category for me? The nature of your intended visit determines what visa category you fall into. If your stay will be temporary, you will want to make an application for a non-immigrant visa. There are more than 20 types of visas available within the non-immigrant classification, covering a broad variety of reasons why someone may want to visit for a short time. These reasons run the gamut from tourism to business to medical treatment to certain types of temporary work. On the other hand, immigrant visas are granted to those who intend to live and work permanently in the U.S. There are three major categories within the immigrant visa classification: family-sponsored classification, including immediate relatives, special immigrants, and employment sponsors. Now let's look at both the immigrant and non-immigrant visa categories in a little more detail. Immigrant visas. Some foreign nationals are eligible for immigrant visas. To qualify for immigrant status, you must fall into one of the three broad categories. You must be sponsored by certain U.S. citizen or permanent resident relatives, by a prospective U.S. employer, or fit within one of the special immigrant categories, and you must be the beneficiary of an approved petition. Did you know immigrant visas are subject to numerical limitations? That means that each of the immigrant visa categories has a certain number of allotted visas. Once that quota is filled, a waiting list is created, and this will delay your arrival to the United States. Immigrant visa categories: immediate relative and family sponsored. Immediate relatives include your spouse of a U.S. citizen, parents of a U.S. citizen, and a child of a U.S. citizen. The child is defined as unmarried and under the age of 21, and it includes adopted children. Unmarried adult sons or daughters of a U.S. citizen over the age of 21 are in a first preference family-based category. Spouses and children of a lawful permanent resident fall into that second preference category. Married sons and daughters of U.S. citizens are a third preference category, and brothers and sisters of U.S. citizens are fourth preference. Let's look at employer-sponsored now. Aliens of extraordinary ability, outstanding professors and researchers, and multinational managers and executives. Professionals holding advanced degrees and persons of exceptional ability, skilled workers and professionals, and other workers. Special immigrants include employment, Iraqi or Afghan translators or interpreters, employment of Iraqis who worked for or on behalf of the U.S. government, others who worked for the U.S. government or consulates. Employment also includes religious workers. Let's look at employment creation. This is the fifth preference. Alien entrepreneurs who invest $1 million or $500,000 in the U.S. One of the other categories is diversity visa program. Visas provided are drawn from countries with low rates of immigration to the U.S. Unlike other types of immigrant visas, diversity visas, or DV, do not require U.S. sponsoring, and therefore no petition is needed. Non-immigrant visas. Non-immigrant visas are for people with permanent residence outside the U.S. who wish to come to the U.S. on a temporary basis. U.S. law requires that people who apply for most non-immigrant visas provide evidence that they do not intend to immigrate to the United States. However, simply providing the requested documents does not guarantee that you will receive a visa. There is no entitlement to a visa. Another did you know? If you are coming to the U.S. as a temporary visitor for pleasure, under U.S. law you would apply for a B-2 visa. If granted, you may come to the U.S. for a temporary period of time, and you may only engage in activities consistent with being a visitor, such as sightseeing, visiting friends and relatives. You would not be permitted to enroll in school and study, nor would you be allowed to work, as those are activities that are not consistent with the B-2 visa. If you are in the U.S. on a tourist visa, it is possible to change status to a different category, such as student, assuming you meet all the requirements for that F-1 visa. Thus, every non-immigrant visa has its own pros and cons, to which you are bound to follow. Because each foreign national's personal situation is different, individuals applying for the same visa may be asked different questions and asked to submit different documents. Under U.S. law, the authority to issue or refuse a visa is vested solely in the discretion of the consular officer abroad. Consular officers have the authority to decide whether the evidence submitted in support of an application is sufficient to establish an applicant's eligibility for the requested visa. Consular officers may also request additional information or documentation depending on their assessment of each person's situation. Let's look at a case. Julianne, a national of Armenia, wants to come to the U.S. to visit her cousin in Boston. She would like to come to the U.S. permanently, but is in the university and wants to finish her degree before trying to immigrate. She has an appointment next week with the consulate and thinks she has all the documentation she needs to get her visitor's visa. Will she be denied a visitor's visa because she wants to eventually immigrate to the U.S.? A desire to immigrate to the U.S. by itself is not a sufficient reason to deny a visa. Julianne must show that she, at this point in time, has a residence in Armenia that she will return to, and that she has compelling reasons to return, i.e. her family is there, she needs to complete university, her family owns property. Since she has not taken any affirmative steps to seek an immigrant visa, her future desire should not be enough to keep her from getting a visitor's visa right now. Immigrant visas versus non-immigrant visas. An immigrant visa is required for a foreign national who wishes to enter the United States to reside permanently, whereas a non-immigrant visa is issued to foreign nationals intending to visit the U.S. temporarily. In order to be eligible to apply for an immigrant visa, a foreign national must be sponsored by a U.S. citizen or permanent resident relative, or by a prospective employer, qualify as a special immigrant, or as an alien entrepreneur, except for winners in the DV lottery program, whereas the non-immigrant visa does not require sponsorship, except in a few rare cases. An immigrant visa gives the right to accept employment in the U.S., whereas not all non-immigrant visas authorize the holder to accept employment in the U.S. Let's conclude here. The Immigration and Nationality Act and its numerous amendments are the basis for most immigration laws in effect today. Immigrant visas. U.S. law gives priority for immigrant status to foreign nationals who have a close family relationship with a U.S. citizen or LPR, those family-based immigration. Second priority goes to foreign nationals who have needed job skills, the employment-based immigration. And finally, to those who are from countries with relatively low levels of immigration to the United States, the DV lottery program. Not mentioned above in this article, but still of importance, are the visas granted to those who have refugee or asylee status. Non-immigrant visas. To qualify for admission in a non-immigrant visa status, a foreign national must meet all of the criteria for the specific category, as well as provide evidence that the visa will be temporary, or visit will be temporary, agree to depart at the end of the authorized stay, possess a valid passport, maintain a foreign residence in most cases, be able to provide proof of financial support, be admissible to the U.S., or have obtained a waiver for any grounds of inadmissibility, and abide by the terms and conditions of admission. Though both the immigrant and non-immigrant visa categories have their own pros and cons, an individual needs to decide the category most suitable to him or her based on the purpose of travel to the U.S. and other qualifying factors. If you have any questions about immigrant or non-immigrant visas, or which visa suits your requirements better, please contact a Visa Pro immigration attorney. We will be happy to guide you through this process.